Okay, you're live now.
Thank you. Thank you. All right, ladies and gentlemen, it is now 4:49, and this meeting is now called to order. This is the Housing and Real Property Subcommittee. Today is February the 15th. And ladies and gentlemen, we have several bills to discuss. However, let me give you the order of these bills that we're going to be discussing. First,
I don't think it's maybe because I don't have an edge.
Hold on, make sure I'm muted.
Trish, can you mute yourself, Trish? Thank you, Trish. The first bill we're going to be discussing is HB 93. Secondly is HB 102. And then after that, we're going to be having a general discussion on the rest of them in very rapid sessions, ladies and gentlemen. All right, so starting with HB 93. And let me pull up my thing here. Matthew, if you could, Matthew, go through general, hang on a second here, HRP, HB 93. Okay, ladies and gentlemen, House Bill 93 is a bill relevant to ground rents, and it's purely a technical discussion. Matt, you want to give us some additional information on HB 93, if you would, please?
Sure. So HB 93 repeals statutory provisions that prohibit a leasehold tenant from providing specified documentation and payment to the State Department of Assessments and Taxation earlier than 90 days after an application for redemption or extinguishment has been posted on SDAT's website. It makes additional technical changes, but it really is just meant to allow acceptance of the notice and the redemption amount in advance of the 90-day, before 90 days have passed. It doesn't actually change any notice requirements. There's still the 90-day period for where the redemption has to be listed on the SDAT website. It just allows acceptance of the check and certification.
And as you heard in the testimony, SDAT had some real problems with receiving these funds and what they had to do relevant to receiving these funds and returning them, et cetera. As indicated, this is a real technical amendment. Is there a motion favorable for HB 93?
Move favorable, Mr.
Is there a second on the motion favorable for HB 93? I see Delegate
Second.
Ellens. Thank you very much. Is there any discussion on HB 93? Hearing none. Anyone in opposition of the favorable motion on HB 93? Anyone in opposition of the favorable motion for HB 93? Hearing none, HB 93 will receive a favorable recommendation to the full committee. Thank you very much, ladies and gentlemen. We will now move to HB 102. HB 192 is a bill relevant to rental property and pet protections. Matthew, if you could expand upon the discussion of HB 92, I certainly would appreciate it.
Sure. So as mentioned, it establishes certain procedures to protect specified pets when property is repossessed in a failure to pay rent, breach of lease, tenant holding over, a wrongful detainer action. It also directs sheriffs, constables, or other officials to take specific actions regarding pets when restoring possession of a premises to a landlord or a complainant. I'm going to share my screen now because there was one sponsor amendment that came in between last week and this week's meeting. Just give me 1 second there we go. Okay. So the amendment you see before you is one I had sent out earlier. This is the sponsor's amendment, and it would just clarify that the judiciary is required to include a link to the fact sheet that the Department of Agriculture creates and puts on its website with any warrant issued in a failure to pay rent, tenant holding over, breach of lease, or drawing a blank here, wrongful detainer action. It simply, this is really just altering their requirements instead of including a description or the location on the website, which probably would just be satisfied by including a link. The one thing I would like to highlight for the subcommittee is that a very similar requirement is made of landlords with the lease. Identical language about a description of the fact sheet and location on the department's website. It may make sense to keep these two provisions consistent and just require that that included with the lease is the link to the fact sheet published on the Department of Agriculture's website, instead of having the two differing standards of description and locate and where the fact sheet's located in one, and then just the link for the judiciary.
And I would like, go ahead, Matthew.
So, a proposed amendment would just be to include this language and then also make 14.804 consistent with what you see here.
And I agree with that, so that instead of the current language suggests that there be a description, as you see here, a description in the lease, as opposed to that, which is what is written. What Matthew is suggesting, that we provide a link, just like it is in 14.805. I think that makes a lot of sense. So what I'd like to do, ladies and gentlemen, is I would like to, first off, make a motion to approve the verbal amendment that Matthew has proposed, making the lease requirements similar to what is shown in 14-805, and just providing a link. That's the motion on the floor, ladies and gentlemen. Do we have a second?
Second, yes.
Great. All in favor of that particular amendment signify by saying aye.
Aye.
Any opposition? Thank you very much.
Aye.
Now, go ahead. I heard someone. Delegate Long?
I'm sorry, I was delayed, Mr. Chair. I said
Okay.
aye to the vote. Yeah.
Oh, thank you. Thank you. So now what I'd like to do, ladies and gentlemen, the other amendments that you see here before you have been emailed out earlier, and I would like to get a motion to approve the written amendments that you see before you.
Move the sponsors amendments.
Thank you very much. Is there a second on the sponsor?
Second.
Second.
All in favor of the sponsors amendment signify by saying aye.
Aye.
All in opposition? The ayes have it. I'd like to move the bill as amended. Is there a second?
Second.
Thank you very much. Any discussion on the bill as amended?
I would like to get amended on at some point.
Oh, sure. We'll do that right now. Well, all right. Any additional discussion on HB 102? Hearing none. The bill as amended is before us for a vote. All in favor signify by saying aye. Oh, I'm sorry, Matthew.
Just one quick question. So are you entertaining additional co-sponsors at this time as well?
Does anyone else want to get on besides Delegate Healy?
I'm happy to, just point of clarification, Mr. Mickler, do we need to pass the bill as amended, or we need to add the amendment to add sponsors and then pass the bill as amended?
It would just be another amendment. And the subcommittee is not really passing anything. It's proposing amendments for the
Recommendations.
full committee. So
Yes,
you could include another amendment just to add some co-sponsors now.
and just for a point of process, subcommittees simply make recommendations to the full committee. So right now, the additional recommendation is for Ann Healy to be added on as a co-sponsor. If anyone else like to add their name, let it be known.
Chair, I would like to as well.
Delegate Long as well. So Healy and Long.
I would like to as well, Mr. Chair.
And who is that speaking?
Delegate Allen.
Delegate Allen. Okay. Healy.
Delegate
Allen,
Lehman.
Lehman.
Voice.
Voice. Siliberti as well.
Okay, so can I just run that back really quickly?
Certainly.
All right, so I have adding delegates Healy, Long, Allen, Lehman, Boyce, and Siliberti. Did I miss anybody?
Put Holmes on there too, please.
Mr. Chair,
Yes,
Can you put me on there as well, please?
absolutely. Want to run through that again, Matt?
Yes, sure. So Keely, Long, Allen, Lehman, Boyce, Ciliberti, Holmes, and Narwaki.
We have them all. Thank you so very much, ladies and gentlemen. So we have the bill. Hang on, mute yourself. Thank you. So we have the bill as amended before us. Is there any additional discussion? Seeing none, all in favor of the bill as amended, signify by saying aye.
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 Any opposition? Seeing none, the recommendation for HB 102 will be put forward to the full committee as approved. Now, did the chairman say leadership meeting at 5 o'clock?
5:15.
5:15.
5:15, very good. So now, ladies and gentlemen, I would like to go to what do I want to do next? Let's go to Matthew. How about a brief discussion? We've talked HB 34. We've talked about HB 34, which is Delegate Hill's bill about the sealing of court records. HB 34, we are still looking for additional amendments on this. So we're going to be holding that until we get something else from the sponsor. Matt, you want to expand upon that if you don't mind, please?
Yeah, that's generally where things are at right now, based on my understanding. I believe it was Delegate Narwaki, you had asked about, or maybe it was Delegate Allen had asked why there was a certain provision left in on Section 2 about collecting information on federal subsidies for rent. That language, based on my conversation with the counsel over in judiciary, was it would be dead language now if you remove the applicability restriction for people who had received subsidies from the federal government but then failed to pay the rent. So it could be removed. Now, if that restriction or if that applicability provision were to be put back into the bill, and it may be necessary, the counsel over in judiciary is going to look through why that was originally added to the bill, then you would want to keep that provision in Section 2 about the collections piece. But other than that, no, we're still kind of waiting on amendments from various advocacy groups.
Any other discussion items? We're not going to vote on this one yet. We're not going to have any other votes on any of these other bills this week. All the other bills that we're having right now for discussion purposes only. We'll be voting on them next Wednesday. Any additional concerns about that bill? Fantastic. We'll have that bill come back up again next week. I'd like now to turn to HB 182. This is in reference to the unlawful restriction covenants. And again, we're having discussion. Matthew, give us a brief explanation of this one, if you don't mind, Matthew.
Sure. So the bill.
Go ahead.
Okay. So the bill authorizes a municipality to execute and record a restrictive covenant modification to an unlawfully restricted covenant if the subject property is within the boundaries of the municipality and specified notice requirements are met. These would include at least 30 days before executing and recording the restrictive covenant modification. The municipality would have to provide written notice of its intent to all persons with an ownership interest in the property. And the notice must be sent by first-class mail and provide information on how a person with an ownership interest may decline to have the restrictive covenant modification executed and recorded by the municipality.
And there was a lot of discussion on this particular legislation during the time frame of the hearing. What I'm going to do now is call upon Delegate Allen.
Thank you, Mr. Chair. My question, I guess, is for Matt. Did we ever get a ruling or anything? Just because I know there's a lot of questions about whether or not we could expand the language in the bill to include counties in addition to municipalities.
So that hadn't been investigated. I can look into why counties were not included originally. To answer your question simply, no, that we hadn't gotten an answer as to why they weren't included originally. But I can certainly dig into that.
Gotcha. Thank you.
I may add to that, Delegate Allen, that the bill, the intent of the bill as provided to us by Delegate Resnick was specifically to municipalities. And if we're going to expand that, then we certainly would, just as a courtesy, talk to the bill sponsor. I don't know if he'd have a problem with it, but if we expand this to language to counties, I'm not quite sure what kind of additional language may be required to be put into the bill. And I don't want to belabor or cause any additional delays to the good delegate's bill, if you know what I mean. But I do think that the question is valid.
Understood. Thank you.
Thank you, yes, sir. Delegate Long?
Thank you, Mr. Chair. And my apologies again to you and colleagues. I'm looking for the notes I took referencing this in the bill hearing, but I know there was some discussion. Maybe somebody could just maybe help me out. Referencing to a sundown town to some extent for this particular bill. And we were supposed to try to work with the language just to make sure it was clear. Am I the only one that's recalling that for this
I
particular bill?
remember that.
Yeah, I just wanted to make sure that we took care of that. Just because I don't believe that it's anything more than just a technical amendment in my opinion, but still I believe it's advantageous that we do that. And again, I trying to locate the notes. I don't believe it's saved in my computer. I have to go back and rewatch the hearing, but there was brief discussion to it. And I'm not sure if anybody remembers or, Mr. Chair, at your discretion, if we could just look into that a little bit more.
Sure. I vaguely remember something along those lines as well. And I'll have to go through my notes and try to figure out where that came from. Did you have any recollection of that, Matt?
I don't. My review focused mainly on the text of the bill as well as what was provided in the department's review of the policy. So I'd have to rewatch the hearing as well, and I intend to after this.
And Delegate Long, if you get with me afterwards, maybe you and I can attempt to ferret this out as well, if you don't mind, sir.
Yes, sir, Mr. Chair, we'll do.
Delegate Allen?
Thanks, Mr. Chair. I was just looking back at my notes to try to help Delegate Long. I think at least what I think he's referencing is there was some discussion about why there's even the option to keep any of this language in the first place, and why this is not compulsory essentially to remove this kind of language from the covenants.
Mm-hmm.
Is that what we were talking about?
That's exactly right. I'm sorry, Mr. Chair.
Yeah, that's fine. That's fine. Yeah.
Yes, that's exactly right. Delegate Allen, it was along those lines. Yep.
So to that though, I have a bit of an answer. I'm not sure how satisfactory it will be, but when you're talking about the modifications that are being done here, it's a modification to an individual property owner's deed, and a property owner controls what is in their deed. This is effectively the municipality coming in and saying, there is this unlawfully restrictive covenant, and we are going to generally remove it from all these documents. And so it essentially goes to property rights and a property owner controlling the contents of their deed. And if you look at other places where, like, for example, in the Homeowners Association Act, there's a provision 11B 113.3 that deals with unlawfully restrictive covenants, and it deals with it actually allows for removal without the involvement of the lot owners. But the property that is the property that's covered by these unlawfully restrictive covenants is the deeds for common areas, as well as things that are in the declaration that apply to all the properties generally, not specific provisions that are built into an individual's deed. So that, I think, is why the drafter included this language, this opt-out provision. Yeah, generally.
So what you're saying then, Matt, if I can make sure I understand it, so these kind of unlawful provisions in 11B, 113B are relevant to common areas, which is different than individual ownership of property. Is that what you're saying?
I just used it as
Example.
for comparison, but yeah,
Okay.
the difference there is that you're not talking about commonly held property here. Well, in that instance, you are talking about commonly held property.
That's correct.
Here, you are talking about individual properties that
Mhm.
you or I or anybody on the call might own.
Mhm.
And
Okay.
historically, the property owner controls what's in that deed, even if it's not enforceable.
Okay. Well, we'll take a look at this, and if anyone wants to talk to me or Matthew offline, please feel free to do so. You all have my cell phone number, correct? Okay, great. So we'll talk about this one again next week. Let's go very briefly to HB. Let's talk about two bills in conjunction with each other. That is HB 101 and HB 435. Is that correct? Yes.
434.
434, but
434, yes. Yeah. And again, these are discussion items only. They're on HB 434. One of the things that the sponsor was looking at was reducing the voting requirements from 80% to 60%. And we'll have to take a look at that. It's if you look at some of the other common ownership community regulations, what I'd like to do is try to look at the other common ownership community voting requirements to see how consistent this request is with other requests, other legislation or laws. Can you mute yourself, Mr. Hinton, please? Thank you. And the other bill, HB 101, this is the Delegate Charkoudian bill. This is reference to the clean energy equipment. One of the reasons why we wanted to have these two together, because they kind of go to kind of the same topic. And Matthew, if you could expand upon that, I appreciate it.
sure. And for each bill, I just wanted to note that I believe there are sponsor amendments that are in process. I know for House Bill 101, there is a sponsor amendment in process. I've been informed by the sponsor in that case, which I believe works out some of the concerns from the Builders and Building Industry Association. And for 434, I believe there may also be a sponsor amendment, but haven't received confirmation of that. But generally, the House Bill 101 goes to these. Sorry, I'm just going to pull up my notes for that one. Well, for 434, what you're addressing there is a reduction in the threshold of unit owners listed on the current roster of the condominium that need to consent to an amendment to the condominium's declaration in general. And then for 101, the bill would establish a specific procedure by which a governing body may grant an easement, right-of-way, license, or lease in excess of 1 year or similar interest affecting the common elements of the condominium for the installation and use of leased clean energy equipment. So it would either be by majority vote of the board of directors or the council of unit owners by affirmative vote of unit owners having at least 51% of the votes in the council. That would be the standard for granting that easement, right-of-way, lease or lease in excess of 1 year or license.
And there are amendments coming on both of these, which is why I do not want to have us to have a vote on this until we get the actual amendments. Delegate Healy?
Yeah, I just wanted to ask Matt if this 80% issue, is that a standard across all these condo and co-op associations and all these other different common ownership groups, or is it differ from each one. Some are 60, some are 75, some are 80.
So I'll take the question and maybe in a couple parts. First off, for HB 434, since that addresses the 80% standard, that is dealing specifically with the Condominium Act. And actually, let me just verify something quickly. No, actually, both bills deal specifically with the Condominium Act, but I will just look at the 80%. For in HB 434, when it comes to amendments to the declaration, it is 80%. There are certain amendments to the declaration that would require unanimous vote, like if you're going to change the limits of a unit, like if you're going to change the limits of a unit or ownership rights within the unit, and that kind of goes back again to the whole property rights issue in general. If I have right to property, then my property rights shouldn't be infringed upon by just a subset of the people voting. There are lower standards for corrective amendments to the declaration.
No, my question is, are these standards in state law, or are they in each condominium association's adoption of their ruling, the governing documents?
These standards that I'm talking about right now are in state law.
Oh, okay. So we're dealing with state law here, so we can
Right.
change it then.
Right.
Yeah.
And
Okay.
one of the things that I wanted to look at is to look at requirements of percentages in state law, so that
Yep.
and there is an issue across the board where condos and HOAs have different regulations, which is a whole different topic. But I wanted to make sure that
Okay.
what we're attempting to do here is not too far extreme, if that makes any sense. And like I said, there are amendments coming anyway.
I think it's time for us to go to our meeting.
I think it is too. With that, ladies and gentlemen, I apologize. We have to adjourn our meeting. And we have a leadership meeting with the chair of the committee. I really appreciate all of you coming out this evening, and we'll see you